Hello, everybody. I am Tony DiUlio. I'm an attorney based out of Philadelphia, but I am now working all over the country handling first party insurance claims and other property damage issues. For those of you who are on here, you probably know who I am, but in the event that you're watching this later or you've just joined us for the first time, my practice is about 90% first party insurance claim and about 10% other types of property claims, such as errors and omissions claims against agents, contractors, negligence claims, claims against realtors. And I do this Lunch and Learn series and all of these webinars to try and give back. It's completely free. I ask for nothing in return. It's just to try and make this industry better. Everyone who's ever heard me talk, I say the same things over and over. They're probably tired of hearing it, but we are an organization of people working against monolith insurance companies. We are the little guy in this fight. So anything that I can do to help provide additional information to make everybody better at what they do, I'm all for it. I also tell everybody the same thing every time. I don't want you to have to send a claim to an attorney. I don't want you to have to send it to me. And I can say that for a few reasons. First, it's honest, and I really do want the homeowners and the property owners to be in the best position they can be. But truthfully, I also know that insurance companies are never going to be doing the right things across the board. Sometimes they do, but not every time. And when they don't, you should absolutely be looking into an attorney who knows what they're doing in this industry. And if you ever have a question, I'm here to help. Hopefully, everybody can hear me on this. If I'm just talking to the air, I apologize, but I'm sure someone will let me know if I can't be heard because you'll just see my lips moving and no sound coming out. But otherwise, I'll assume that we can be heard and that we can get this thing going. Today is a fantastic class, not to toot my own horn, but I really enjoy this class because it is one of the ones that comes up most often when people ask me questions about what to expect when it comes to bad faith and litigating a claim. Uh, it is unbelievable the amount of times I will get a phone call from an adjuster who says, "Hey, Tony, guess what? I've got a great bad faith case for you." And if you've heard me talk before, you've probably heard me say, "Oh, yeah, we'll prove it," because most claims are not bad faith. We're going to talk about that today. And then we're going to talk about when you do hit a wall with carriers, when there's no other options left, what you should be doing to promote litigation, to set expectations properly for your clients, to make sure you've got the best winnable case moving forward. All right, so that's enough of background. We've given people enough time to sign on. We've got a good group today. So let's dive in and take a look. All right, how do I switch sides there? There we go. For some reason, I always want to be on my left side when I see the video. It just makes more sense mentally for me. This slide, as I tell everybody, has some of the most important information you could ever ask for as somebody in this industry. And that's because it contains my personal phone number and my email address. Just today, I got a call from a roofer down in Virginia who had some questions about claims, needed to talk about some issues, and they got the information I was able to pick up, answer them right away, and everybody worked out for the better. So use the phone number. I am happy to answer calls. I'm happy to answer text messages when you've got issues. I'm not always available. I wish I was. That's not true. I don't wish I was. I consider myself a family man. I like time with my family. So if for any reason you send me a text message or give me a call and leave me a message and I don't get back to you right away, you have permission to bug me. You can just text me again and say, "Hey, Tony, I sent you a text yesterday. Can you let me know what's going on?" I got a text today from an adjuster who's on here. It says, "Hey, Tony, check your email." I see that he had emailed over the weekend and I will be responding this afternoon. I'm happy to do it. But since I'm not always available, since I'm in depositions or trials or other presentations, or just doing something with my family, you have permission to bug me. So use the phone number, use the email. I will be happy to respond. All right, so diving into today, we have got the final part of our Perfect Claim series. If you haven't checked out the other parts of the Perfect Claim series, I will have them linked on our Facebook, on our website, on YouTube. You should go back and check them out. But for today, we are talking about bad faith and litigation. What to do when you run out of options. As I've put in all of our series webinars, not every claim is perfect. I don't want an insurance company to come back and say, hey, Tony, you said that the adjuster should have done this. They didn't do it. Haha. That's why we denied the claim. Sorry, carriers. That's not how it works. You're bound by your contract. We all are. This is a contract between parties, and that controls for this. So just because an adjuster doesn't do something that's on here doesn't mean the claim can be denied. You will be held responsible accordingly. All right, now that I have said that, we can get into what we talked about last week as a very brief summary in our part 11 of the series. We talked about all those things you need to do after the claim has been resolved, getting recoverable depreciation, getting reviews online to bolster yourself online to get more claims in the future, the procedures for obtaining those reviews from your company, and other additional issues that came up like errors and omissions claims. If you didn't get a chance to watch it, head on back, take a look. I think it was a good class. Today, we are going to talk about bad faith, what constitutes a bad faith claim, how to prove a bad faith claim, and why they're so difficult to prove. I did a full class on bad faith, and I'm going to try and condense it because I really want more focus on the litigation side today. But about 1.5 or 2 years ago, I did a class on bad faith, and I actually started to do the math. And I figured out that across the country, of claims that went to trial to get an actual judgment on a bad faith claim, only 0.2% of those claims had successful bad faith judgments against the carrier. Now, that doesn't mean that there weren't more in settlements or that their other claims weren't resolved in some other way for bad faith. But when claims went to litigation and went all the way to judgment, 0.2% actually had an award for bad faith. These aren't common claims. I know it feels like they're common, and we're going to talk about why that's the case. But I just don't want there to be any misconception. It isn't easy to be successful in bad faith claims. Now, with that being said, I'll toot our own horn a little bit here at WDB Legal. We have had multiple bad faith verdicts just last year, let alone over the course of my career. We push bad faith really hard because we recognize that bad faith is what carriers respond most to, right? A regular roof claim or water loss, they don't really care about the outcome. But when they get bad faith verdicts or bad faith settlements, that's something that perks them up. So we push it really hard around here. Going into this, it is important that we all have a basic understanding as to what bad faith really is. Now, bad faith is governed by either a state's statute or the state's common law. It can be different in every state. So make sure wherever you are working, you have an understanding as to what constitutes bad faith. A lot of states don't have a statute. They don't have something that you can look to and say, oh, look, this is what bad faith is. Or if they do act in bad faith, here's what the damages are. Like New Jersey, for example, has no bad faith statute on first-party claims yet. We were successful a couple of years ago lobbying for bad faith, but they limited it to third-party vehicle claims. So we're going to be looking to expand that over the next few years, but there's nothing in New Jersey. You have to go to the common law, the cases. But other states like Pennsylvania have bad faith statutes that you can look to find out what bad faith might be. However, most states will follow this common outline or theory as to what bad faith is. And what that is that an insurance company must first act unreasonably. That's super broad, right? What is unreasonable? The second question you have to answer is, do they know that they are being unreasonable? That's your general standard. Again, it might be tweaked based off of case law or based off of statute, but that's really what you're going to be looking for in a general sense. Just being wrong. Carriers are wrong all the time, but just being wrong, even if they're really wrong, isn't bad faith. And there's a ton of things that insurance companies do to try and limit their exposure. But I want to first focus on some examples of bad faith. Now, these are all cases that we have either settled for bad faith money or we've actually gotten judgments for bad faith against carriers on. So these are all real world actual examples. First one was one of probably my favorite bad faith case I've ever had. It was the true, golden gun, if you will, for bad faith. The carrier had accidentally did a reply all and CC'd the public adjuster along with the independent adjuster. And what they got was a chain of emails where the independent adjuster had written to the carrier and said, hey, I did an evaluation of the loss. I went out and inspected. The cause of the loss was wind-driven rain. And the carrier, the adjuster, the desk adjuster, wrote back, CCing the public adjuster, and it says, well, we can't deny wind-driven rain as a cause of loss, so let's call it something else. Obviously, that's ridiculous. And when I tell people that in a live reaction where I can see them, they all laugh because they realize how absurd and how bad faith that actually was. Another great example is where a carrier breached state law. In New Jersey, under the Unfair Claims Practice Act, a property owner can demand the carrier get a contractor who will do it for the costs that they estimated for. In our case, the carrier refused to do that. We had our own contractor do an estimate, says, can't do it for your price, carrier. You've got to get your own contractor out here to tell us that it can, in fact, be done and that they're willing to do it for that price. Well, the carrier sent out some contractors, but none of them were willing to do it for that price. And the carrier said, well, we're not going to change our estimate. We're going to send it to appraisal. Well, they're not allowed to do that. And what happened is the carrier ended up paying bad faith damages on this because we had to incur an umpire cost and appraisal costs that never should have been incurred. And we were able to get attorney's fees and punitive damages as a result of that. Another great one is a carrier withheld an undisputed amount as leverage against a property owner when they were negotiating the rest of the claim. This one actually went all the way through judgment, and the judge found that there was bad faith against the carrier because they said, you can't do that. Not only does state law prohibit it, but it's clearly unreasonable to withhold the leverage, withhold those monies as leverage against a property owner who is already suffering. Last but not, two others. State Farm, we had multiple cases about this. There's actually a class action currently going against them about it, but we were successful already in trial against State Farm where they were trying to enforce their access endorsement that limited coverage. But when they told the insureds about this, there was a part of the endorsement says, we're not intending to change your coverage. So State Farm says they're not changing their coverage when they in fact were changing the coverage and they were reducing that coverage. Well, the judge came back and says, you can't do that. You can't tell an insured you're not intending to change their coverage and then in fact reduce that coverage. More so, we've now found out that State Farm never told the state about this provision where they said that we're in fact reducing coverage, and they included that in the policy. Well, what State Farm didn't realize we would figure out, you cannot reduce coverage in a renewal. And as a result, we have this ongoing class action because State Farm has, without question, now reduced coverage in a renewal. And Pennsylvania came back and the insurance department actually wrote an affidavit saying, we never would have approved this if we knew that you were going to be considering this a reduction in coverage. Last but not least, we actually had another case that went to verdict where the carrier was attempting expert opinions without ever actually getting an expert. They just simply came out and said that there was a water damage from groundwater in the property, but they never actually sent out anyone to make that determination. They never sent plumbers or engineers or anyone else. They just said it was groundwater when we had direct evidence that it was not, in fact, groundwater. It was from the plumbing system. All of these constitute bad faith, and they all can allow for things like attorney's fees or punitive damages, of course, depending on what your state allows. There was a question from John Jackson. We need to apply bad faith to hazardous materials. What do you think? So I imagine this question is focusing on things like asbestos and other hazardous materials that can be found during the construction process. And I would argue that if you've got direct evidence of hazardous materials that the carrier outright ignores, once that evidence is produced, that could constitute bad faith. If there are regulations about how you have to handle the hazardous materials in your state and the insurance company doesn't pay for that, that is both unreasonable and it's providing knowledge that they knew it was unreasonable, so long as you provided them the test results and the state regulations that require that abatement of those items. Again, I try to answer all the questions. I said this in the chat early on, but if you have a question, not only will I try to get to it, but if you just label it when you start, say question, and then label what it is, it'll make it easier for me to trigger in the chat exactly what questions I need to address. All right, so Bad faith, everyone calls me, says, Tony, I've got a great bad faith case. Well, what isn't bad faith? Delay alone is often not enough to be bad faith. Most courts have come down and said, look, delay alone doesn't create any level of damages. There's other issues that come up. It by itself isn't going to be bad faith. It might in a really egregious circumstance, but I haven't seen it yet, so it's got to be really, really bad. I do have one that is going to trial next week where the carrier has failed to deny the claim for over 4 years, forcing us into litigation through discovery, through a number of other issues, and we're pressing bad faith very hard on that one. I'll let you know how that turns out. There's a question. Does a carrier have a duty to actually inspect a loss? That is a great question. The short answer is actually it depends. There is no affirmative duty that they have to inspect the loss in the event that there is nothing to inspect or that the cause of loss has been reported and determined not to be covered ahead of time. So let's say, for example, a homeowner calls an agent and were to say, hey, agent, a flood came through my neighborhood from the hurricane and flooded my property. Am I covered? They could simply come back and say, no, I'm so sorry, you don't have flood coverage under this policy, and there would be no affirmative requirement to inspect that. However, let's say the public adjuster gets involved and says, well, wait a second, I realize they might have said the property flooded from these floodwaters. That's not actually what happened. It was actually a backup from a sump pump, and they've got a sump pump endorsement, so this is a covered loss. Now they've got an affirmative responsibility to investigate the loss. And if you request that inspection, they should, in fact, inspect that property. It can get a little nuanced, but most times, if you're involved, they will have a responsibility to inspect the property. Another great question from Mike Muma is bad faith better defined as malicious intent? That depends on the state. For example, in Pennsylvania, the courts have come down and said, no, you do not need malicious intent to show bad faith. And it's one of those concepts that is often misconstrued that people think that, right? People think they need to show, oh, this person was a racist or this person was a misogynist or there's some basis for the bad faith. That is not the case. In a lot of states, the courts have come back and said, no, that's not, that you don't actually need to show any type of malicious intent. You don't need to show ill will. It can just be enough to be unreasonable and them knowing it's unreasonable. Again, that will be guided largely by state law. So other aspects that are often not enough to be bad faith, simply not paying enough money, right? A damage dispute is rarely going to amount to bad faith. Not changing their mind simply because you asked, right? Oh, I asked for a reinspection. They didn't give me the reinspection. That alone probably isn't going to be enough. Never inspecting might be, but a failure to reinspect, not. Basing a decision based on a recurring expert, and I put that in quotes because I find it hard to believe that some of these people are actually experts, but just because they've used the same person over and over, Pete Spavoda, you don't necessarily have bad faith. Their use of an expert over and over again doesn't automatically amount to it. Making mistakes or being negligent isn't actually enough in a lot of states to amount to bad faith either. Now, if you get combinations of these factors, maybe you can start triggering bad faith, but anyone individually usually won't be enough. Why is bad faith so difficult to prove? Well, it's because of this question, or this, not really a question, should have been a comment, but prove to me what I know. It's really hard to do that, right? How can you prove what somebody knows or what somebody is thinking? You might get lucky with something like with my claims. You've got, me doing webinars. You've got, oh, Tony, you know that you knew the standard and you didn't do it. It's the reason that insurance companies don't have a lot of material out there, because any material that they have, they would end up being beholden to, and they don't want to be beholden to it. So proving what somebody knows can be really difficult. It is your job to make them know, to document the file in a way that can prove they will know when this comes to a bad faith claim, that they know. And how do you do that? There's a few things that you can do, but here is the most important one. I couldn't write it enough. I could have kept writing it. I should have just put it on the whole page. Writing. Put it in writing. Put it in writing. If I need to say it again, put it in writing. Using written correspondence is the number one way to prove that a carrier knew something. I'm going to repeat it one more time because it is that important. Putting things in writing is the number one way to prove a carrier knew something. Here's what I mean by that. You have a loss where you've got an opinion as to the cause of loss and the carrier is completely ignoring it. You put it in writing and say you've denied the claim, but you've ignored these factors, A, B, and C. Well, later on, when this case goes to litigation and I have to prove the carrier knew what they were doing was wrong, right? One of those prongs of the bad faith claim. I can show them that letter. I can show them the email and say, hey, look, court, jury, the carrier knew exactly what it was supposed to be doing because they were told about it. Not from me, not from my lawsuit, before that, from the adjuster who was handling it. Put it in writing so you can prove that they had knowledge of it. It is never going to be enough to just have the conversation. It should go without saying, anytime you have a dispute with a carrier over any issue, coverage, damages, conduct, put it in writing. It is far, far, far too often, and candidly, I do it with my staff sometimes, where they'll say, oh, I followed up with them 15 times. I've called them and left messages. Did you put it in writing? Do we have proof of that? Short of having to get our phone records to show the phone calls were made, did you ever write and say, hey, I followed up 6 times. I've called you 3, and this is my 5th email. Have it in writing. In that writing, I put in here a quote that I want all of you to adopt. You can take it. If you want to tweak it a little bit, feel free. But the quote is an important one because it's one that allows some level of responsibility to be shifted to the carrier. And if you note here, it says at the bottom, if any of the above is incorrect, please let me know in writing within the next 5 business days. If I do not hear from you, I will accept that as your confirmation that the above is accurate. If you don't have that line or a line similar to that in your letters, you're missing out. It is a no-brainer to be including in your correspondence because it puts the onus on them so that when they start ignoring you, I just had a claim come through today where the adjuster calls me and says, look, the carrier's ghosted us. We followed up with them for over 60 days. They are just not responding. Well, one of the letters that I'm hoping that adjuster wrote, because this was all regarding an appraisal demand, was that, for example, the policy requires you to respond to an appraisal demand within 20 days by the naming of your appraiser. I've now written that in the letter, and I end with this line that says, if anything I wrote above is incorrect, let me know. Otherwise, you're accepting it to be true. Well, in that scenario, we now have direct proof the carrier, not only from their own policy, but from the correspondence, knew that they were ignoring a demand for appraisal under the policy, knew that they have 20 days to respond. They've got no reasonable basis to do it, and they're just not responding. So, include it in your letters. If you don't take this down, if you want to come back and watch this later and rewrite it down, fine. You want to email me or text me and say, hey, Tony, can you send me that language that I'm supposed to include at the end of my letters? I'm happy to do it. But here it is. Take it, use it. All right. So what do carriers do to limit their bad faith exposure? Carriers aren't stupid as a whole. People that work for the carriers, not so bright. But carriers as a whole aren't stupid. They have processes in place to insulate them, to protect them so that people like me don't get bad faith awards against them. There's a reason that bad faith verdicts are so uncommon. It's because they know what they're doing. They're wrong and they're unjustified, but they know what they're doing. So the first thing that they do, and the most common thing that they do, is get experts. They try to get third parties involved as often as they can because they simply say, oh, not me, it was them, you can't hold me responsible. And the case law in most states pretty much says that if you're relying on a third party to determine the cause of loss, and you've accepted that, maybe you're wrong, maybe it's obviously wrong, but it's not bad faith because it was at least reasonable to rely on that third party. The other thing that they do is they make payments on claims. And they make payments in 2 different ways. So one of the things that they'll do is they'll make payments on portions of the loss and come back and say, well, look, I've paid $100,000 on this claim. Clearly, while we have a disagreement, I haven't been unreasonable. And they do that on large losses so that it helps insulate them from bad faith claims. The other thing that we've started realizing carriers have been doing, because we've had a lot of adjusters provide analytics for this, on large loss area claims, so things like hurricanes through Florida, carriers will pay out nearly 100% on small value claims with almost no fight whatsoever, so that it changes their metrics for when they show what percentage of claims they pay as a whole. By way of example, if they only took percentages into account and they pay 100% of the claims that are under $100,000, but they only pay 3% or 10% of the total value of claims over $100,000, their metrics are going to show a lot higher percentage of claims paid simply based off of volume for those small claims versus the large losses that come through. It's really wild because they can use that information to go to the courts and go to the insurance departments to say, hey, we're not in violation. Look at the percentages of what we're paying out. We're actually doing a really good job. No, you're not. You're just front loading all of it so that those large losses you don't have to end up paying. Another thing that they do is they add in a line to a lot of their letters. And this is just a form for them, but it helps insulate them from bad faith, where they say, if you have any additional information you want us to consider, please provide it. We'll be happy to take a look and reevaluate the claim accordingly. That makes them look really reasonable, right? Well, if you're not taking advantage of that opportunity, then you're missing out on a chance to prove they're acting in bad faith. And the best question out there, perk up. I want your ears to be listening because I didn't put this in a slide. And I want all of you to know that this is what you should be putting in your letter. When you get that letter, and you feel like you've exhausted your arguments, you've provided them so much already to prove your case, and they send that final letter that says, we're standing by our denial, but if you've got any more information, let us know. This is the question you should ask. What could I provide you that would change your mind? It is one of the most powerful questions that you could ever ask an insurance company. And it's powerful for two very, very important reasons. Either you get a good response from the carrier and they say, oh, if you could provide me X, Y, or Z, I'd be happy to review that, and that might change my mind. Fantastic. I'll work on getting it for you. That's a good response because it does give you direct evidence as to what you could give them to change their mind, and everybody works out to be happier. Or you get a much more likely response of, there's nothing I could think of that you could provide me that's going to change my mind. And what that does is something very important. It shows that they have closed off their eyes, that while they ask for more information, they don't actually want it. There's nothing you could give them. You could get a time machine and show them it happening live, and it wouldn't be enough to change their mind. So when you get that response, you're now building the bad faith claim. That all of these requests for information, it's BS. They don't actually mean it. They've made up their mind from the beginning, and they're never going to change it. The other thing that they do is they point to the errors of the public adjuster or the contractor. And that can be very powerful because it helps them shift that burden or shift the appearance of the burden to the public adjuster to say, wait a second, you want to call me unreasonable? Look what you did, right? You put, an extra, 1,000 feet of tile in your estimate when it didn't exist in the house. You did these egregious things. Now, as a matter of law, that doesn't actually change anything, but in the perception of the judge and the jury, it absolutely does. It is hard to be asking for bad faith from a carrier if things haven't been entirely above board on your side. So you should be doing a few things to make sure that doesn't happen. Did I mention putting it in writing? I'm saying it again because it's that important. Put it in writing. You want to be the nicer, more reasonable person. It doesn't mean you can't be aggressive in your position, but you don't need to be aggressive to the carrier. You get more bees with honey than you do vinegar. And I know that this is a polarizing topic with public adjusters, and that some people think that there's a scorched earth method of public adjusting that is more effective. If it works for you, more power to you. It doesn't work in what I've seen, in the experiences that I've had, both with public adjusters and carriers. It is almost always better to have a good relationship with the adjuster on the other side. You will have more success and more payments in those claims than when you don't. But you can still make your point. You can still present your position, and that still does a ton for both you and the insureds. You just don't have to be mean about it. It really, people are much more likely to listen to you if you don't have that mean demeanor to you. Now I'll leave it there. I did a class on negotiating already. I'll probably do another one this year because I think it's something that people lack in. But you really should take it to heart when I say you'll get more bees with the honey than you do vinegar. You want to document your file. So make sure you're making sure you're getting all the photographs, all the measurements, everything that you need in your file. I did a lunch and learn on that as well. You want to give the carrier a chance to fix it. This is one of the ones that gets missed most often. I get a call from an adjuster. They say, "Oh my gosh, Tony, guess what? The carrier did this thing. It's so ridiculous. They put it in writing. We got them." And I tell them, "Okay, great. But I stand by my statement when I say I don't want you to have to send a case to me. I do like to make money, no secret. That's why I do what I do. But I also like to help people. And the truth is, if you could point out to the carrier the egregiousness of their conduct and get them to change their mind, the client will pay less than if they have to get me involved. The bad faith is never a guarantee. So I don't want to sign up a client. If they can get a resolution without me, let's do it. So give the carrier a chance to fix it. But not only is that better for the client, it's actually better for the bad faith claim in the end. Because if you give the carrier a chance to fix whatever this egregious error is and they still don't do it, it's only made my case better. And now I've got a better chance at getting those attorney's fees so that the client doesn't have to worry about paying me on top of paying the cost of the work. Also, consult an attorney. If you really do think you've got that great case or that great dispute with the carrier, call an attorney who knows what they're doing in this industry. If you want to call me, great. I will be happy to talk to you. But if you're not going to call me, call someone else who does know this industry well and understands the policies and the procedures the carriers have to follow. Don't just, you really don't want the homeowner going to, their family law lawyer or their business lawyer or someone else they happen to know who's a lawyer just because they know them. It's not going to be doing them any benefit to go that route. So do what you can to consult an attorney who knows what they're talking about. All right. So we got through the bad faith stuff. I'm happy with the timeline. And let's go into the litigation. And I see there's a question. I don't know if John was asking me or asking Mike above, but he says, sign and seal the lab results and deliver it to them. Will that work for you? If you provide the lab results for the asbestos that they were talking about earlier, or lead in the property, whatever it may be, providing the results is an absolute must. But it also needs to come with a demand as to what needs to be done as a result. So you need to send them the lab results. You also need to send them the code or the building ordinance or whatever you're relying on that says, hey, because I have asbestos, I have to do X, Y, and Z. Here's where that is based off of. And then you send the estimate that is associated with that work. All three of those things are necessary if you're really going to be pushing the bad faith on those claims and even payment on those claims. That's what you should be providing every time. All right, so litigation. Litigation comes up a ton from obviously people who contact me because I'm a lawyer, but it should also be coming up with your clients. And it's something that shouldn't be shied away from. One of the biggest problems is a misconception of what litigation really is, right? People see courtroom dramas on television and they see, depositions that get aggressive and you're getting grilled under a hot light. That is not reality. It is not at all what they should be expecting. So part of your setting expectations when you're talking to an insured should be talking about, hey, what happens if things do go wrong? There are a ton of adjusters that I speak with that never end up telling the client the answer to that question until it's already there. They always want to present this concept of things will never go wrong. I've got your back. Things are going to go perfect. I'm going to get you all the money you need. I got it. I got it. I got it. And I understand the value of doing that from a sales perspective. I do. But if you are getting clients based off of misconceptions that things are going to go perfectly, you're going to have more problems down the road. You should set your clients' expectations that you are good at what you do and you get great results from your clients. But one of the best things that you do for your clients is that when things hit a wall that is outside of your control, it's not over. That there are opportunities to pursue that the clients are still not going to have to worry much about. Litigation is just having a third party determine the outcome of the case with opportunities to settle in the middle. And what's nice is the client keeps the control over that process, that they always have control to say yes or no to settlement talks, um, to oversee the process. But they don't have to be terribly involved. This isn't something where they're going to be getting a weekly phone call to discuss strategy and next steps with the litigation. It can be very hands off if the client wants it to be that way. And again, working with an attorney who does this often, you usually find an attorney like myself who does it all on a contingency fee. We front 100% of the costs for the clients. So there is never a scenario where my client will end up in a worse position after using me. It just doesn't happen because I'm fronting those costs. And either we've gotten them money, which happens in 99.9% of the claims, or God forbid something hit a wall and we were unsuccessful. The burden is on me, not them. So having that expectation set early on is important. And one of the questions I hear all the time is, well, when should I go to litigation? When is it time to finally pull that trigger? Well, here's your list. Number one thing, track your suit limitations. If your suit limitation is coming up, and I don't mean tomorrow, please, please, please do not send a case to an attorney, me or any other, the day before the suit limitation runs. None of us are going to be happy about it. I don't care what attorney you're talking to, and they might blow smoke up your ass and say, oh, it's fine, I don't mind. They're lying. They do mind. I know they mind because we all mind. Don't send it to us a day before. Try and give some weeks lead time at the least. Truth is, claims shouldn't be adjusted for 11 and a half months. It shouldn't take that long to adjust a claim, so you shouldn't have to wait that long to go to litigation, but give some weeks lead time if you can. Number two, the carrier won't budge on payment. If they've just hit a wall and they're just saying, look, we're not paying anymore, it's covered loss, but we're not paying any more on this thing, and you can't get any movement on that result, it could be time for litigation. They won't budge on coverage, right? This one's even easier because coverage disputes have to go to litigation. There's really no other avenue for it like appraisal, and we're going to talk about that in a moment. But if they just won't budge, it's time. Don't just sit on it hoping they're going to change their mind in 3 months. It is so unlikely that that's going to happen. It's just time to send it to a lawyer. There's no reason to wait. You're only delaying things for both yourself and your expert payments on a loss or on litigation, or you're delaying things for your insured, and that is not good for anybody. Also, when you've exhausted all other options, so you've done everything you can now. You've contacted the insurance department. You've gone on social media. You've gone up the chain. You've done everything you can. There's just nothing left. Now could be a good time for litigation. So we've got a question here from Mike Muma. One question my client considering litigation have asked and are concerned with is, will I be able to get insurance after litigation? How best to answer this? Mike, awesome question. I get it all the time too. So glad you asked this one because it does come up a lot. Here's a few things that everybody should understand. A claim, there is a database that records when claims are made for both properties and people, so that insurance companies can go on and get a clue report that says, all right, you've gotten X, Y, and Z claims in your past. We can see that. They also have the loss runs that are produced as a result of claims that can be shown to carriers when you've got a loss for commercial properties or even homeowners, but they don't ask for it as often with homeowners claims. It's what I tell clients, it's called the insurance permanent record. So they can see that. What it doesn't reflect is any difference in that claim when it goes to litigation. That there is no difference in there that, oh, they sued on this one versus not suing on that one. It changes absolutely nothing from underwriting perspectives as far as I've ever been told. Now, granted, I have deposed a ton of underwriters on this. I've talked to people in informal situations about it. But I don't work for a carrier, so if this is different somewhere, so be it. But from what I've seen and what I've been told, there is no difference from underwriting perspective if a claim goes to litigation versus a claim is simply made. So it makes no difference for future insurability. However, once a claim is in litigation, it is deemed an open file, an open claim with those carriers. Getting insurance while there is an open claim can be more difficult. So not because it went to litigation, it's not more difficult simply because you sued, but it could be more difficult because it's considered open while litigation is ongoing. what I tell homeowners and property owners for commercial claims, if you have a loss that has been paid or denied or whatever has happened, and you want to switch carriers, go for it. Doesn't change your rights to a claim at all, won't affect my litigation. Do it before I file suit. And all it takes is a phone call with me to plan, or even you as the adjuster to say, hey, look, we've been denied. I think you should go to litigation. Before we pull that trigger, go talk to your agent and get a new carrier. Because right now, when you're having that conversation, the claim is closed. And getting a new policy won't be affected by the fact that there's an open claim. And then we file suit, claim gets reopened under the old policy, but they're off to the races with their new carrier and all is well. Hopefully that makes sense. If you have any other questions on it, either put it in the chat, give me a call afterwards, and let me know. All right. Question from Steve Nat. Can a carrier deny appraisal on the basis that it is the 1 year to bring suit? End quote. Stating that the bring to suit paragraph states action and an appraisal is an action. Another great question. There have been multiple disputes over this, and let me tell you my results. What other attorneys have done, I don't know. Every claim that I've had, and I think this is still a true statement, every claim that I have had where I have had to bring suit to it with a carrier where they have refused to go to appraisal under the suit limitation, I've gotten bad faith damages in settlement. And the reason being is there is no actual binding case law that says a appraisal is a suit against us or an action. The carriers like to cite, there's one old case from I think it's the 80s, where the court came back and said that appraisal is equivalent to a lawsuit, and thus it is an action. It is not a binding case by any means, and it has not been followed by any courts since. The arguments that we put forward have been very successful. So my position is very strongly the carrier cannot deny appraisal as a result of the suit limitation provision. However, doesn't mean something won't change down the road, and it doesn't mean you should wait. I tell every adjuster out there, if you know a suit limitation is coming up, I don't care what the position or posture of the loss is, contact an attorney so that we can tell you what to do. Because one of two things will happen. Either we'll get a tolling agreement with the insurance company if they're kind enough to actually give it to us, or we will file suit or file a writ to protect that statute. And we've got things in place that can make sure that that happens so that the appraisal can still finish, or the adjustments can even still finish. Never, 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 if you can avoid it, let that suit limitation pass without doing something to protect the statute, even if it's an appraisal, even if you're still adjusting and everything seems hunky-dory and they're doing a great job and everybody's happy. Do not let it pass if you can avoid it. But if it does get passed and you need to file suit because they've refused to go to appraisal, I'm happy to have a conversation about that. All right. So we've talked about when litigation is a good idea. What about when it's not a good idea, right? Carriers continuing to negotiate, right? If they're still in an open posture stance, it's probably not time for litigation yet. You don't want to leave money on the table, both for your sake and the client's sake, if you could get it without having to file suit. If they've asked you for something, there's an open request for information still. Don't send it to litigation until you've responded and you get a basis of either denial or coverage off of that information. So if they're asking for invoices, receipts, estimates, if they are still open to the claim, keep working on it. I know it can get frustrating. I know it's a delay tactic on their part. We all know that. But in the event that you can actually get a response and coverage, it's better for the client. That's what you're there for. So give them the information they ask for, assuming it's reasonable. And the catch-all, if you haven't exhausted all options. If you're not getting responses from carriers for 60, 90 days, contact the insurance department. That usually will at least get them to respond. If you've got issues with responsiveness or changing adjusters 9 times and delaying the claim, have your homeowner go put a complaint on social media. Tag them in Facebook and Twitter, and you will get faster responses from the carrier because those are tracked by the carriers and do often get a faster response. Do what you can. It's better for you. It's better for the client. Again, trying to stress how much I mean it when I say, if you don't have to send it to the litigation, great. I don't want you to. All right. There is always this dispute of appraisal versus litigation. Some claims should go to appraisal. It's true. It's detrimental to me. I am a huge advocate for appraisal rights at the legislative level and the court level. I fight claims often where I'm hopeful that the court will come back and say, just send the damn thing to appraisal. Again, it's better for the insureds. I don't want to have to litigate a $15,000 roof dispute. If they've already accepted coverage on the roof and the only question is it repairable or does it need to be replaced? Great case for appraisal, right? Assuming you're in a state that allows the entire scope to be appraised, that's a claim that should be going to appraisal. Appraisal's great for damage disputes, things that are straightforward. It's a simple one or two things that are really at issue. Those are the claims that are for appraisal. The more complex a loss gets, the more moving pieces you have with, loss of rental income, loss of business income, multiple areas of property in dispute. The more complex it gets, the better it gets to be in litigation. And the reason I say that is in litigation, we've still got the control. In the appraisal level, you're passing that control to third parties who ultimately can decide everything for your claim without any more input or say from your side. And candidly, by the way, they shouldn't have any more say or input from your side, just like the carrier shouldn't have any say or input once it goes to appraisal. Always remember, because this is a brief aside, I get complaints constantly about the conduct of carriers during appraisal. And the carriers mess up appraisal all the time, and they are wrong. But just make sure you're holding yourself to the same standard that you want to hold them to. You don't want them contacting their appraiser, make sure you're not contacting yours. It is a mutually agreeable situation for appraisal that no party is involved in it. So make sure you're keeping it all above board. Anyways, to get back to this, the more complex it gets, the more control you're going to want to have over it so that you don't get a situation where it's a split the baby because the two appraisers are just looking at it and saying, look, there's a lot of moving parts. Give me this one and take away this one and taking it that way. So the more complex it is, the more likely it is you're going to want to go to litigation on it. This is a pet peeve. When you ultimately want to send a claim to appraisal, there's a few rules that come into play. And here is the first rule: send everything. Hiding something from an attorney never goes well, ever. It's never been a successful tactic for anyone in my entire experience as an attorney. Send everything. There is an opportunity for us to review it. We can determine if something is confidential, if something doesn't need to be produced for one reason or another. We can make that call and we can talk about it. We can have conversations with you and the client and figure out the best tactic to go with that information. But send everything. Too often, I get a file from an adjuster and it's a denial letter and an estimate. I'm like, okay, well, what about the photos, right? The most obvious thing in the world. Send me the photographs. Okay, great. All right, what about all the other correspondence? Where was your response letter to the denial? By the way, if you have a denial that you want to fight, every single file you should send to a lawyer should have a rebuttal letter from you to the carrier explaining why their denial is wrong. Every single file. If you don't have that letter, you're doing something wrong. So where's that letter? Where are the emails back and forth that with the carrier? Where's everything? Just send me everything. It makes life so much easier on me and the client, because otherwise I end up going to the client and I say, hey, do you have these things? And they're like, I gave that to the adjuster. Well, why don't I have it? Right? If they sent you receipts, why aren't you sending them to me? Send everything. Send everything. All right. Hopefully that was clear. Hopefully I don't need to repeat it in rule number 2. Send everything. All right? Shouldn't be difficult. Super big pet peeve of mine. Send everything. All right, now for rule number 3 and 4. You should be sending a summary. If there's a letter in there that already has the summary, great, don't recreate the wheel. But if not, send a summary of the claim. It helps us when we're reviewing the emails. I hope you realize it's not just your claim in this week. I've got multiple claims in this week. I've talked to multiple adjusters about other claims. I might not remember when you send me the file that just comes from you. Oh, here's the one we talked about. I'm so sorry. I don't necessarily remember that. Put a short summary. I'm not saying you have to do a timeline of everything that happened, but just a summary. Also send the client's contact information and your position on the claim. So, client had a fire loss, date of loss of January 5th, 2021. Carrier paid $100,000. Our estimate is $350,000. They're ignoring, the asbestos abatement, the siding replacement, and the tile floors throughout the property. Here's the client's contact information. Fantastic. Love you. That is what I want to see. Also, make sure the client knows we're going to reach out to them. More often than not, I prefer to be the one reaching out to the client. It just makes it, for scheduling purposes, it's just easier. If you give my contact information to a client, I get calls from clients and it's like 6:30, 7:30 at night. I'm not in the office. I miss it because of dinner. Who knows what? I don't know the phone number that's calling me. They don't leave a message. I mean, it just gets messy. So it's much easier if we reach out to the client. So just tell the client, hey, I've talked to the attorney. They're on board. I've sent them your contact. They're going to reach out to you within the week. Great. Sounds like a plan. You'd be surprised the number of clients that we have called where they're like, who are you? I didn't know. Okay, we'll see. So make sure you let them know. Mike asks a fantastic question that I'm going to put up here because I want to make sure everyone knows it. So you want us to send you everything for litigation? With a laughing face. Yes, send me everything. I'll pound my fists on the table. Send me everything. All right, good. We've hit it again. That's probably enough. Organizing your file when you send it to an attorney. I get files from some adjusters that are one giant PDF. Now, if that's the case and that's the best I'm ever going to get out of them, so be it. I'll live with it. I'll make it work. Not the best for me because then I have to go through and separate all of those PDFs as I get it. But whatever, I know you're busy. If that's the best you can do, so be it. But in an ideal world, you should never have to do that because you should have a file system. By the way, go back and check out, I think it's my very first Perfect Claim series that talks about organization of your files. Go to part 1. It'll talk about organizing your file. You should already have this done. This should not be something that you are just sending me or having to do as a result of litigation. But this is how it should generally be set up. You should have all of your different letters and emails, your correspondence separated, right? Things that you've received from the carrier, things that you've sent to the carrier, and then any correspondence back and forth between the client. That one doesn't matter as much who sends which way, so that can be a whole file itself. You want to separate all of your photographs. And these can have subfolders, by the way. So your photographs might have initial inspection and the date for that inspection. And then maybe you went back and took more photographs. That should be a different folder. Don't just throw it into the same one. Organization makes life so much easier for you when you're adjusting a claim that you should do this regardless of litigation. I can't stress enough how really much better your life will be if you have this level of organization, but it does make my life easier. So also doing it for that reason. Estimates should always be in there and separate them out, right? Separate them out between yours and the carrier estimates. If you've got estimates from contractors or roofers or plumbers, separate those as well. Then you've got a folder for all of your proofs, right? Things you've sent to the carrier to build your case. And that can include the receipts or invoices, roofing reports, anything like that to help build the claim. And finally, a folder for your administrative documents, your contract, your letter of rep, all that background stuff. If you have your own intake form, can go into that folder. This is a very basic way to do it, but it can save everybody a lot of time, including yourselves, when you're adjusting a loss, when you can quickly go to places to reference information. Expectations. You always want to talk to your client about expectations. And I think somebody actually put in here that they always set the expectations and plant the seeds of the next step. Nathan, I'm going to call you out because you did it, and it's worth pointing out that you really need to be doing this throughout all the stages of your adjustment of the claim. Nathan is absolutely right that you should be planting seeds throughout the process of what could happen down the line. Not necessarily what you want to happen, but what could happen. And when you do that, you want to talk about litigation. And these are lines that I tell my clients in every call I have. Every time I have a new client, I tell them these lines. Litigation is great at a lot of things, but it isn't fast. I wish it was fast. I do, but it's just not. However, again, I'm going to toot my own horn one more time. There is two main search engines out there for attorneys, Lexis and Westlaw, that really do a lot for this industry when it comes to organizing cases. However, they've also started to do something really cool, which is track analytics for attorneys. And so I started doing some research because I was curious. One of the analytics that they check is the average turnaround time from the date a complaint is filed to the date a case is closed, whether it's closed by settlement or judgment or whatever the case may be. And I was actually really pleasantly surprised by my numbers. Attorneys talk all the time in other states about how long their cases take, how everything, and my cases aren't fast, but I realized I'm a heck of a lot faster than other people. I averaged, it was 189 days no, I'm sorry, 289 days, 289 days from start to finish for a case, less than a year to litigate an entire claim from start to finish. And I was proud of that. Once I found that number, because I hear these horror stories from other public adjusters working with attorneys where cases have been going on for 3 years. What's going on now? Full disclosure, COVID changed all of that. I haven't looked at my numbers since, but because of the court timeout, obviously those numbers are not accurate. I'm going to trial on cases that are absolutely 3 years old because they've sat around forever because of COVID. But we are now getting back to normal timelines on cases. So I'm pretty confident that I will keep that status up of my faster turnaround on cases. Another thing that I tell clients all the time is that 98% of cases settle. The chances of you having to walk into a courtroom are slim. Very, very slim. You're going to have to walk into a courtroom. The most work you're going to have to do on an entire case in litigation is sitting for a deposition that averages about 2 hours, and the attorney's there to prep you and be with you the whole time, so it's really not a big deal. They can be as hands-off as they want to be. I tell clients that I'll give them updates on the really big stuff that happens, but they might not hear from me for 2 months unless they want to. If they want to have that kind of relationship, I'm happy to do it. But this isn't something where they have to be involved if they don't want to be. I've been doing this a long enough time that I've got a pretty good system, and I will call them when I need them. But I'm always here for them if they want. But I also tell them that the clients are always the ones driving the bus. And this is really important. And I say this to you guys because I do every once in a while have an adjuster call me and say, hey, why'd you settle that case for that amount of money? I didn't make that call. The client made that call. They are always the one driving the bus. I explain to them, I'm like a GPS. I can tell them to turn left or turn right, but I won't turn the car for them. It is up to them to do that. And if they want to keep going straight when I tell them to turn left, I will redirect them the best way I can to get to the results I want, or that they want. But that is my role, that they are the ones making the decision. So if they want to settle a case for 50%, because I've told them there's risk. Every case has risk. They all do. I wish there was a perfect case. It doesn't exist. So if they want to settle it, they settle it. That isn't my call. I will do what I can to press them with the information that I've got, but it's ultimately their decision. And you should have the same expectations and tell them the same things when you prep them for litigation. I always want to end my lunch and learns. Well, I'll get to the questions, but I always want to bring up MAPIA. MAPIA is an association of the Mid-Atlantic Public Insurance Adjusters Association that I'm involved in, and we have been growing, and we've been growing fast, and we've been growing great. We've elected a new board, and we are really pushing the industry now for big changes. We are getting proactive with legislation. And what I mean by that is we're not just going to wait for the insurance companies to put bills forward and fight back. We are going to become proactive and start pushing forward with things that protect the homeowners and public adjusters, like having formed contracts in states that public adjusters have been prosecuted in, creating better timelines for claims. The number one problem I want to fix personally is the timeline of claims. Carriers are extending them out far too long. They're using it to their advantage where they adjust a claim for 10 months before making a payment just to run out ALE. I mean, it's really egregious. So, that type of work is what these organizations can do. MAPIA is a great one. If you're not part of MAPIA, join another one. But it can do a ton of good, and it's not very expensive. MAPIA for an entire year is like $300, and it's tax deductible. So there's really no excuse not to be involved in an organization like that. Great question, and the answer is absolutely yes. Will you be doing another MAPIA educational summit like the one in 2022? Absolutely. We're going to be announcing next month officially, but there will be PAGPS 2023. For those of who attended, I believe it was an absolutely phenomenal seminar. Candidly, one of the best ones I've ever been to. The teachers were top notch. The programs were great. Food was fantastic for what it's worth. Really, really great. And again, really inexpensive. My goal in this industry is to get the education out there free if I can, but for as low a cost as possible, because I really want this industry to be better. There's too many bad adjusters out there. So we will absolutely be doing another one, and we're very much looking forward to it. So there were some great questions that came. As always, I address every question that comes in, even if it's unrelated to the topic. If you guys have any additional questions, throw them in. But I want to make sure that I hit these because some of them were really fantastic, and I think deal with some of the misconceptions that occur in the industry about sending cases to litigation. So this one is: in states where there is almost no bad faith, like Virginia, how do we present the case to an attorney? Well, we talked about presenting the case above. But the reason this question was so important to me is there doesn't have to be bad faith to send it to an attorney. We don't all live in Florida, and honestly, Florida's changed now, so it's not going to matter. But we don't all live in a state where attorneys automatically get their fees. I certainly don't focus my practice in those states. And I've created a system here where we can still take those claims and make money for the client and still be profitable as a law firm, so that everybody, to the best of our ability, has representation. I take claims that are worth $10,000, and I do it because I found that other attorneys just refuse to. I don't make money on those, but they are fights that are important to have. And I can do that in places like Pennsylvania and New Jersey because I've got a great staff here. I've got a great system, and we can still make those claims worth it for everybody involved. And I stand by that. I really want to. I will very rarely turn down a case in those states, at least, as a result of value. As I've expanded, and I've got cases now in Oklahoma and Tennessee and Florida, Texas, wherever I need to go, I've got these files. Yes, it's hard for me to take a case that's worth $25,000 out in Oklahoma, but I'm going to be doing my best to be expanding this practice so that we can do that everywhere, so that everybody gets representation. This was a longer one. Insurance companies say they do not need to do any more work on a claim because it is over a year old. I requested payment for interior damages, which I provided proofs, photos, requested they send a policy language saying they don't have to work on a claim because it's over a year, yada, yada. Here's what you can do. A carrier cannot stop adjusting a loss simply because it's 1 year old. I actually have an active claim in North Carolina right now that was initially litigated in Philadelphia. The courts agreed and said, hold on, carrier. They literally, the denial letter was, we're denying the remainder of your claim because you've hit your suit limitation provision. That's ridiculous. The carriers are not off the hook simply because they are judgment proof. I will be happy to file suit against a carrier who refuses to adjust a claim simply because it is beyond the suit limitation. So if you have that in writing, I'm happy to file suit, and you should absolutely give me a call on that. This one got cut off on the sides. In New York, New Jersey, how do we get attorney's fees paid on bad faith claims? And how do we get an attorney to be happy to take a bad faith claim under $10,000 or $100,000? First and foremost, New Jersey, without question, claim does not need to be worth $100,000. I will be happy to help. I've got claims in New Jersey. I think my lowest in New Jersey right now is $7,000. And Jersey bad faith is tough. I have one New Jersey bad faith. I actually just won it last year. So I do it, and I do it because I think we're good at what we do and we're aggressive. But we're happy to help on those. But a claim doesn't have to have bad faith to go to a lawyer. Doesn't matter what state it is. There are attorneys out there that would help with that, myself being one of them. So let me know. How do you address interference in the appraisal process by an attorney? So there's a few things that you should be doing. Document the interference, right? If they've provided phone calls, or if they've come to you've gotten correspondence from them, write your objections down and email it to them, send them a letter, make sure you document it accordingly. You always want to create that documentation. Remember, writing. Number two, you want to provide them with the policy language that says that this is an independent process, right? That they are not supposed to have any biases, and that any interjection by attorneys or by a carrier, whoever it may be, is inappropriate. Number three, if it's something that you believe has created a situation in the appraisal that cannot be overcome, right? A bias that has been created an impossibility to a fair appraisal, you can pull it from the appraisal. This gets a little more hairy because of who demanded the appraisal, where did it come in. But if you want to go that route, I highly suggest speaking with an attorney yourself beforehand so that you can make sure you do it the right way. I can walk you through that process of if you're going to pull it, this is what you want to do, but that would be your ultimate decision to make if you feel that the process has been tainted that much. All right. When does delay and lack of responsiveness, or should be responsiveness, constitute bad faith? It's hard. Like I said, I've got a case right now where it's 4 years and they haven't denied the case. That's going to be bad faith, in my opinion. But just delay and lack of responsiveness alone usually is not enough. As I mentioned above, use the insurance departments to push a response. Again, the insurance department might not care, but what it does is the insurance department will open a file and they will get a response from the carrier. That is going to be the triggering effect to get you the response you want. Also, use social media because again, that's tracked by an entirely different area of the insurance department of the insurance company. And if you use social media, you can often get good responses. Ed, I actually do have an attorney in my office who's licensed. He's actually from Chicago initially, so he's still licensed out in Illinois. We've handled 2 claims out there currently, but again, I openly admit it's somewhere where I don't have local counsel yet, so the small cases are harder to be able to represent as a result. But larger claims, I'm more than happy to help with and have done so before. All right. What do you do when the opposing will not reply to requests to discuss your differences of your appraisal? Go to the umpire. Appraisal process is set in place for a reason. If the carrier's appraiser is just refusing to communicate, you've got an umpire for a reason. If you've done things the way I suggest to do them, your umpire was selected early on in the process. Either you've selected him or it was court appointed, and you've got your umpire already in line. Umpires are not only intended to resolve the ultimate dispute, the dollar value. They can be used to resolve other issues. You can use umpires to create timelines for appraisal. You can use them to create requirements as to presenting the loss. You can use them for any reason you want, so do it. I know it's frustrating when they don't respond and you want to do something more, but that's why the umpire is ultimately there. Any experience with CSAA delays? Absolutely. CSAA has been brutal for their handling of claims, along with companies like Guard. I know has been really bad out here for responsiveness. One of the great things about CSAA, though, is if you ever need, I've got good relationships with them as an organization and some of the people there. So I can usually make a phone call or two and get some traction on resolving a claim. So if you need something with CSAA in particular, give me a call and I'll see what I can do to help with those as well. Question here before we officially close this out from Jason. When the carrier is slow on response, do we want to force the written denial? Oh, great question. You want to force a response. You really do. It's not that you ever want to force a denial. Obviously, that's never beneficial to the insured, but you do want to force a response. You want something in writing. If you know they're going to deny it, have them deny it. I tell people all the time, though, that your best chance to change a carrier's mind about a denial is before it's made. So make sure you're doing everything you can to document it, to present the loss appropriately, to do all of that before they actually send the denial. If you're up against the wall, you know they're denying, you just need to get to that next stage, whether it be litigation or something else. Yes, you need the written denial to do that. But make sure you are doing everything on your part to change their mind before that denial comes through. There is another question from Ed here, a bit longer. Should an insurance carrier's ROR, reservation of rights, letter placing limitations on the appraisal determine what the appraisal panel can determine for that claim's amount of loss? We recently had a retired judge's umpire states that all he could be, it got cut off there, states that all he could be valued was the insurance adjuster's scope of work. The carrier's ROR does not set the amount for the appraisal scope, period, end of story. In every state that I've worked in, case law, state law, the binding law from that area will. That is what you should be looking to when determining. So easy examples out here. Pennsylvania allows for the entire scope, everything that's in dispute, to be part of the appraisal process. New Jersey, only the scope as determined by the carrier can be appraised. So you've got clear determinations based off of case law, and that's what should ultimately be going forward. If you work in a state that does not have that, the ROR is not the contract. If you are in Illinois, and I haven't looked into this, Ed, but if Illinois has no good case law one way or the other on the scope of the appraisal, the contract is what is controlling the policy. If the policy says amount of loss, it's really simple for me. I send the carrier a letter that says my amount of loss is 100,000. Your amount of loss is 20,000. That's the difference in the amount of loss. That's what's being appraised. End of story. So you want to look to the insurance policy and use that with your umpire as to the amount of the appraisal. All right, I think that is everything. Thank you so much for the comments. I really do appreciate it. Any reviews you guys can do and give us, I'm never going to turn them down. So, go on Google, Facebook, YouTube, wherever it may be. And I always do appreciate the reviews. As always, here's my contact information. Again, my phone number and email address. Reach out. Let me know whatever else you need. And I'm very excited to start the next series that we are going to be doing. That as of now, barring any changes, is going to break down the common policy exclusions and endorsements that we see one by one. So we're really going to dive into wear and tear throughout the policies, the differences between different carriers, things like that, so that you know the best ways to argue them moving forward, so that, again, we put the best foot forward. All right. I think that is it. We got one last question. Should an attorney included all directions to pay in NOI? I'm assuming notice of intent for NOI, although I'm not positive that is the NOI that you're referring to. The attorney, anytime an attorney is getting involved in a claim, they should be included as one of the payees if they have an interest. Candidly, there's a lot of times I'll write letters for clients that I'm not charging them for. So in those situations, I don't need to be on the check, but otherwise they should be. All right, I think that is it. I always try to keep this as close to an hour as I can. But we're pretty close. So thank you all so much again, and I will see you on the next one. Have a great one. Oh, and Happy New Year to everybody.